Good afternoon, everybody. If you would, please come in and have a seat, and we'll call the House Rules Standing Committee to order, and we're going to ask Dean Green if he would open us with a word of prayer, please.
Let us pray. Lord our God, merciful God, and almighty Father in heaven, we beseech you, look upon us as your children. And in spite of everything, all of us are allowed to be your children and to praise you for all the good you are doing. And for all of us, as we come before you in this place of democracy, that we pray in your name to bless us and guide us and direct us. And we're asking that you guide us over those rough and tumbly spots in our lives. And as we do the will of the people, we pray, oh Father, that we do this in your name. And Father, we just ask you now that even in these hard and serious times, that you may hold fast to each and every one of us as we try to do thy will. Bless us now, Father. Guide us and direct us in the coming days. In the holy name we pray. Amen.
Thank you, Dean Green. At this time, we got a couple of items that are in the committee we want to deal with, and I'm going to recognize Chairman Leverett, who chaired our subcommittee on lawsuit reform, to speak to Senate Bill 69.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I am presenting to you Senate Bill 69 for your consideration. This is part of the governor's so-called lawsuit reform or tort reform package. This is the bill that would regulate litigation financing. That is financing. Oh yeah, I'm sorry. The LC number, excuse me, is LC 492382 ECF. No, I'm sorry. That's the old one, isn't it? Never mind. Hold on a second. What is the? Yes, 2385S. Thank you. That's the one that has all the changes that I have marked on my draft so that I can explain them to you. So the bill, what I said previously is still accurate. The bill would regulate litigation financing and would set up a regulatory infrastructure, if you will, where out of the Department of Banking and Finance, where they would be these entities that provide the service of litigation financing, which is defined in the code, would have to register with the Department of Banking and Finance. They would have to disclose the department information about who the principals in the company were. And then there are certain prohibitions on certain actions and prohibitions on ownership by foreign adversaries. There is also a requirement that they enter into written contracts with the folks to which they provide this kind of financing. They have to have certain disclosures on it. There has to be a 5-day right of rescission or cancellation in the contract, and there are certain penalties if they violate any of those provisions, one of which is the contract is not enforceable. There are also provisions that allow for enforcement by the state, involvement by the Attorney General, and then an effective date. Now, there are a few changes in this bill that were made in committee, so it differs from what came over from the Senate, and there's a very finite number of them, and I thought I might just touch on those if you've looked at the Senate bill and are just curious about the changes. So one of the changes is on page 5 in lines 112 to 115. There was a requirement there that in order to register, you had to put in, if you were a corporation, you had to put in your articles of incorporation specific language about litigation financing. That was stricken because at the time you apply and form your corporation, you aren't registered, and so it would be a misstatement to include those in the articles. So it was sort of it was a nonsensical requirement. Nobody could comply with it because of the sequence. You normally form the company and then you would apply. So that was removed. On line 1, I'm sorry, I'm still looking at my draft. On page 6, where there is a percentage stated about the middle of the page for entities of the disclosure of people with an interest in the entity, that was changed from 5 to 10%. That's more, 10% is apparently more standard in the banking world, and banking and finance had requested that. There is a prohibition about engaging in litigation finance if you are a foreign person, a principal or sovereign wealth fund of a foreign adversary under 15 CFR Section 7.4, that language was clarified. The Section 710.3 is brand new. That was requested by Banking and Finance and deals with denials of applications to be registered. So if your request for a license is basically denied, that section deals with what it can be denied based on and what the appeal process is if you feel that you have been wrongfully denied. We also added some exceptions. There is a prohibition on basically kickbacks. You can't have rebates or fees paid for signing up with one of these financiers. And there was a prohibition on that, but it was so broad it arguably would preclude them from paying their employees and their sales agents, so that we've added language to make that permitted. There was a prohibition on assignments, but we've narrowed that a little bit to clarify when that can apply. There's also a prohibition on someone providing services having a financial interest in the litigation, and that has been clarified. It's services that are related to the litigation itself. There also was an exception. There's a provision on joint and several liability that basically says a litigation financier can have joint and several liability if there are any kind of penalties or fees or sanctions imposed in the underlying case that they financed. And they put some limits on that it would have to be if the financing is $25,000 or more in funds, and if the right of repayment is fixed by contract, the liability won't exceed what they were going to be paid under the contract. And then there was a word, there's an exception for regulated lenders, and we took the word regulated out so it would apply to any lender, as affectionately known as the Aunt Sally exception. And the effective date. It was one other section. There's a section 710.10 would allow the banking department to use their existing sort of computer system, for lack of a better word, in their existing licensing system for this licensing as well. And then the effective date was changed. I think it was going to be July 1, but Banking and Finance said it may take us more than a couple of months to get all this set up. So it's been placed to January 1, 2026 for the bulk of the bill. There is also a provision that provides that litigation financing agreements can be discovered. You can get discovery or you can find out about them in a lawsuit. And that will be effective upon signature. So, but the rest of it in terms of what I view to be the primary thrust and what most of the bill involves would not be effective till January 1, thus giving Banking and Finance some time to get all this set up and ready to go. So that is the bill, Mr. Chairman.
Okay, you've heard the explanation. Do we have a question? Chairman Williams.
Yeah, thank you, Mr. Chairman, and thank you, Chairman Leverett. You've done an absolutely fantastic job perfecting this Senate bill. But my question is, I actually absolutely agree the Department of Banking and Finance does a stellar job of licensing and regulating financial entities in Georgia. But to that point, do they have adequate staffing? And has there been any consideration of making sure that there's been sufficient amount of appropriations headed that way to be able to allow them to do this job effectively with no detriment to the other regulatory duties that they're pretty much overstaffed with already?
I have to confess, I do not know the answer to that question, but I would assume those discussions have been had between the governor's office and that department to confirm that, because they did have input on the bill.
Good. Representative Miller, is that you?
It is, Mr. Chairman. Thank you. And thank you, Mr. Chairman, for your work on this bill. I did want to just call the committee's attention to lines 273 through 270. It's a long sentence. Let's just go all the way to the end, 281. You described the provision, which is this provision in the bill, that will hold a funding company jointly and severally liable for the conduct of an attorney in the case, or a person who is a party to the case. You said they can be held liable in your presentation, but the wording of the bill says they shall be liable. And so I guess what I'd like to understand, because I think that and I'll say this in a second, I'd like to understand why, if a funding company abides by every single rule in this bill should it pass, and they become a good business organization under the law, they do everything right, including not participating or trying to influence the litigation. They can't control what the lawyer does in court. Why are we going to force them to be liable for something they cannot control? It seems to me that this is designed to just flat out discourage anyone from ever becoming a litigation financier. And I would like to know also if we couldn't just change the shall to may upon a showing that they actually did something that should require them to be liable.
Well, thank you for that question, and I appreciate the lady correcting me. You were correct. It is a shall. It's mandatory. So it does provide for mandatory joint and several liability if the financing is above that limit, and subject to the limitation that the joint and several liability would not exceed the amount of the financing. I think, I mean, as you recall, and just for the benefit of the members of the full committee, we did have some discussion on this, and the lady who asked the question, whom I respect very much, proposed an amendment to change that. And I know the lady does feel that is not a good provision. I would say, as I mentioned in the committee, I don't want to assume the policy, but it would seem to me that the policy of this is that when the nature of these litigation financing contracts, they are not like a conventional loan. And in essence, the litigation financier is almost becoming a partner with the law firm on prosecuting the lawsuit. And so while they are prohibited from any kind of control, I think there's some concern that the possibility of control might still be felt. And effectively, they are joining into a joint venture with a law firm on the litigation, and therefore having them be jointly and severally liable will make sure they're cautious and careful and do their due diligence about the matters in which they fund, which I think has been a concern in the past, is that the financiers get into the business of just generating lawsuits to generate money regardless of the merit. Now, I suspect not everybody would agree with that characterization, but I think that's been a concern in this space. And so that is why I believe that particular policy position was taken in the bill.
Understood. And one follow-up, Mr. Chairman. I understand and have great respect for the chairman, as the chairman well knows, and certainly understand the spirit of this bill. It's a consumer protection bill, and as I stated in committee, I think there are lots of good things about this bill. I guess just to state a response to the chairman's point, how would a litigation financier be able to predict in the future, if they've done everything under this bill, to make the right call and behave perfectly? How are we going to then hold them yet to account for the conduct of the attorney and the people who are in the case? The litigation financiers are not parties. They are not at the table. They cannot give advice to the lawyer about how to conduct the case, as this bill is very clear. So even if they're perfect, they're going to be forced to shoulder the responsibility of an attorney, who normally is the person who pays when there is a finding of frivolity or inappropriate conduct in the case. I just would urge my colleagues respectfully to reconsider that position. I think it contradicts the spirit of the bill, and it really just disincentivizes anyone, even if they do everything right, from being in this business.
Okay, was there another question? Leader Hughley, do you have no, you wave, okay. Any other questions? Okay, you've heard the explanation from Chairman Leverett. Do I have a motion? Have a motion do pass by substitute and a second. Is there any discussion before we vote? Hearing no discussion, we'll put it to a vote. do pass by substitute. That's LC 49238-5S. Is that correct? Yep. Okay. All right. All those in favor say aye. Aye. Any opposed? No. The ayes have it. It carries. Okay. We have one other bill for us to be considered today. Senator Kaiser, come on up and talk to us about Senate Bill 255.
Thank you so much, Mr. Chairman, members of the committee. This bill codifies the legislature's investigatory powers. All legislative bodies, whether state or federal, have an implicit constitutional right to do their duties legislating. And to do that, it requires investigation of the facts and conditions, circumstances that you're trying to regulate or legislate. That's long established United States constitutional law. In Georgia, we also have a code section. It's section 45, 15, 17, and 19 that specifically grants us that power of investigation and to issue subpoenas to accomplish our purposes. That code section was directed at Attorney General, and it gave the legislature the same powers that the Attorney General has to investigate. In addition, we of course will pass resolutions either on the House side or the Senate side, or joint resolutions that can create specific investigatory committees and grant them through rule or resolution investigative powers. In the course of chairing a committee that we've been looking into some activities of the District Attorney Fonnie Willis in the Senate, this has been litigated. And the Superior Court in Fulton County has agreed that our legislature, both the House and the Senate, have the power to subpoena witnesses to conduct investigations within the scope of any resolution that might have created them. And they upheld our powers on all grounds alleged. In the course of going through that litigation, it occurred to me that it would be wise for us to codify this in a code section under the General Assembly, and that's what this does, and that's Title 28, deals with the General Assembly. So it sets forth that both the Senate and the House of Representatives can, through their rules, your general rules of procedure, or through resolutions, can authorize one or more committees to investigate certain subject matters, and that's in the course of our legislative duty. It specifies in this that that gives you the power to administer oaths and have sworn testimony before these committees, that you can compel the attendance of witnesses through an issuance of a subpoena, and you can compel the production of books or documents or things through a subpoena for the production of those documents. And finally, you could also require a witness to give us a deposition to members of the committee. So these are powers that we already implicitly have, and the Senate granted our investigative committee through resolution, and it codifies them. It is bicameral in nature. Equal powers to the House or the Senate if they were to exercise the right to create such a committee or to have a joint committee to do that. Interestingly, I went to NCSL annual summit this summer in Louisville, and they have all those little seminars or sessions on different areas. One of them was titled "Everything You Need to Know About Legislative Subpoena Power." It's just like they created it for me. And I went, and legislators from every state were talking about how frequently they exercise it. And they use different methods. Some of them have standing investigative committees that are joint. Many times they told just a litany of case law where every state has upheld the legislature's powers to do investigations and subpoena witnesses and documents. In many of the cases, they told stories about where the push, give and take was between the legislative branch and the executive branch. Some governor's offices are not as open as ours and would not provide the documentation or the data needed to form a budget. And so the legislative body would ask for certain documents and financial records from different agencies to do it. But it was quite interesting that it's universally agreed, and I felt like it would be wise for us to just put it in one code section, codify these powers that we really already have, so that it would be useful for different legislatures going forward here. There is a change in the committee sub. One was literally a typo. a code section. We had it mistakenly 45-15-9, and it should have been 19. The other was that we just flipped the order of 2 paragraphs. That was done between negotiations between the Speaker's office and the Lieutenant Governor's office. Didn't change the wording, just did that. And there was one little tweak where it said, we can create an investigative committee through a joint resolution or through joint rules of our legislative bodies. Some legislatures just have it built in their rules, like standing committees is what that was referring to. I hope I didn't take too long to talk about what's really a simple subject, but I'm happy to answer any questions.
Couple of questions for you. Leader Hughley, I think, has a question.
Thank you, Mr. Chairman. To the senator, when this House becomes majority Democrat, what is going to stop us from investigating an officer of the Senate?
This doesn't say you can investigate the other body, but you could form a special investigative committee and look into other matters.
Is that the intention? Is that going to be allowable under
Absolutely.
this?
Yeah, you know, the voters rule. Whatever party's in control, and it may be that way here before too long, that there's one body, Democratic, and one Republican. They could still work jointly, or they could have separate investigative committees. Did I get your vote?
Okay, Representative Miller.
Thank you, Mr. Chairman. Good afternoon, Mr. Senator. Excuse me. Just a sort of a procedural question. Oftentimes, law enforcement, district attorney's offices, attorney general's offices, who routinely use these types of tools to conduct investigation, have fairly extensive standard operating procedures that govern them, that set guardrails and boundaries, that hold them to account for how they use, and frankly to keep them from misusing this extraordinary power. I would like to know, do you anticipate there being some level of time spent drafting some sort of standard operating procedure for both chambers, either body, if we are going to codify this, which I don't disagree with the courts about the power. Just wondering if we are also going to give some thought about intended and unintended consequences and maybe draft some guardrails around how we use this power.
Yeah, that is accurate, and that's one reason we specifically say through joint resolutions or joint rules. I think that would be the appropriate place to do that. The other sort of guardrail, as you mentioned, is the resolution creating the investigative committee, or whatever committee it is that you give investigative powers. Any subpoena issued or witnesses called by such a body has to be within the scope of the authority granted to it.
Okay, and then so I guess would it be on a case-by-case basis so that the under what I think you're anticipating here is that this is addressed per resolution as the cases come, that we then would define and decide what the guardrails are, or would you be open to some sort of standing policy that encourages best practices and has a consistent guardrail for how we use this? Just wondering your thoughts on that.
This contemplates that could be done, and it may be done in the future. This is something that may not be used for another decade. It may not be utilized if our current committee process is getting all the information we need voluntarily. And for the large part, we are that. But no, I would contemplate that we might have joint rules or resolution guardrails between the House and the Senate, or each body might adopt their own to have parameters that resolutions. But you're protected because no committee can exercise these powers unless there is a resolution from that body granting them this power. So it's going to take the majority of the House to form a House committee, and that resolution will say what your mandate, your limits of jurisdiction, or vice versa in the Senate, or if they find it something necessary to have a joint committee, which would be encouraged to build those rules in.
Thank you. Last question. You said it might be a decade before we use this, and you also referenced the district attorney, Fonnie Willis, in Fulton County. When was the last time, or whenever has the General Assembly attempted to codify or exercise its subpoena power that you're aware of, aside from Madam District Attorney Fonnie Willis?
Can't tell you the year, but there is Georgia case law of a Georgia House committee that had a similar type investigation of the activities of a member. It might have been the Senate committee, but that was, let's say this much, this is my 19th year, it was before then. This is the first time in my tenure that we've done it in the Senate. And I don't think it's something that will be frequently used. I think it would be a rare instance, not like a standing committee doing it unless that's the will of the committee. I did leave out one thing is, so how do you enforce these subpoenas? And it specifies in this bill that if you were to issue a subpoena and it was ignored or denied for some reason, you go to the Superior Court where the witness is being compelled to testify and ask them to enforce it through a motion for contempt.
Thank you, Mr. Chairman. Senator, it probably was a Senate member y'all investigated way back, but thank you for work on
Probably
this.
was.
And this is just getting in the weeds. I'm just trying to understand it. Line 15 says the Senate or the House of Representatives may, through rules of procedure or through a resolution, authorize one or more committees of such chamber to exercise the investigatory powers. So when we pass our House rules each year, that could be written in our House rules that
Right.
the Ethics Committee can investigate, or
Just almost like where you create all the committees and the number of members, you could create an investigative committee by your rules.
And if it-
each legislative session, I mean, not biennial.
And to follow up to that, so if it happened to be absent the rules, but became a compelling need, then through resolution that we could do that.
Right.
But it comes through the whole body either
It would
way.
have to be, and under either of those circumstances, either the rules have to be adopted by the body and a resolution would have to be adopted by the majority of the body.
Thank you. Just
Sure.
Thank you.
Representative Evans.
Thank you, Mr. Chairman, to the chairman and the well. Have 3 areas of questions that I'm going to be fast, hopefully. The first one is just sort of a nerdy, making sure we write good law code question. Since we've got 45-15-19, and that's referenced on line 20, I was wondering if there was any consideration for doing away with that code section and just having this, because it seems like we're setting up a new code section, but then we're referencing an old one, and I was wondering if there was a particular reason why we did it that way.
We wanted this to be additive, cumulative, to make it clear that this in no way abrogates the prior authority by that statute. In fact, if you look towards the end of this, starting on lines 53 on, it makes it very clear that the implementation of this would not be interpreted in any way to abrogate, modify, or supersede, or cancel out the existing powers that we have both implicitly in the Constitution and in that existing code section.
Because 45-15-19 is currently, an interpretation of that is currently on appeal to the Court of Appeals, is that right?
Not that I'm aware of.
Okay. I think you would probably agree with me, just the political climate everywhere, that if one party is in charge of these investigatory committees, they're either party, Democrat or Republican, you've got a chance for abuse. And so I was wondering if you would be open to an amendment about making sure that the committees were bipartisan, that we have a requirement that they be bipartisan in relation to their numbers in each chamber.
I think that should be left to each body through their own rules or resolution, however they want to handle that. And we adopted rules of the Senate Special Investigative Committee, which, by the way, were unanimously adopted bipartisan. Every member, both Democrats and Republican, agreed to our rules, and they set forth who would serve on the committee, the number of minority party members that would be included. We built in that the minority leader would be and the designated members. So I think that's probably best left to each chamber to decide. And as you all have pointed out, one might be Democratic one day and one Republican at the same time, and they both may have different ideals of how to go about it. I think I like that flexibility better.
Well, wouldn't you agree, though, that if we put in some guardrails that said the membership is always going to be commensurate with the numbers, that we, number one, ensure that they're always bipartisan, number two, we ensure that they don't get out of whack with at least the wisdom of the voters that sent each of us here in our respective districts, and that, you know, to your point, when not if one day I get to wear a majority party badge, there wouldn't be bad behavior on our side to keep the then minority party out of these committees. Don't you think it would be safer for everybody if we put in some guardrails in that regard?
I think you might be starting with the presumption that the legislative function of coming up with good policy by doing investigations is a partisan venture, and I don't buy that. You know, I think that what we ought to be doing is passing good laws. In fact, my committee's task is not to in any way undermine any prosecution. Its job is to find out ways to restore public confidence in the criminal justice system, to not weaponize the judicial branch, to restore our faith by looking for legislation that we can pass or amend to restore that confidence. So the committee is looking at some behavior that has greatly undermined public confidence, but not to prosecute or criticize that individual, but to find laws to make the guardrails, as you're talking about, what's appropriate prosecutorial behavior, so that our citizens will have more faith in that system. So I would think that's just our example. It might be something we're looking at in, the price of gas or something, and what's a good policy for doing that. That wouldn't really be a partisan ideal.
No, I agree. And my point was just to make sure that we stay that way. My last question is trying to understand, and I think you've answered a little bit, the purpose could be, we could have any number of purposes, but we would hope that any body or joint combination of the bodies that authorizes one of these investigations has a purpose, is looking to find out something in order to do something about it, if there is a problem, as opposed to just airing dirty laundry. So I was wondering if you would be open to having a subsection added that requires the committee, in any committee that's authorized, to report out any findings, conclusions, or recommendations, because otherwise we've just set up committees to investigate and talk and perhaps embarrass, but without any, so what are we going to do? We've investigated, and then what?
Yeah, that's the purpose. It's to do our legislative function, to pass bills, and to get the information needed to give good, logical, sound decisions, create good public policy. Our committee, by its resolution, does require such a report. What did we learn? What are our findings? What are our suggested amendments or changes or creations of new laws? I don't have a problem with that at all. I don't think that's necessary, because I think it will be in any resolution that forms one of these committees, because that implicitly, that's the reason for these, is to assist us in the legislative function, into passing good laws. So I don't mind if that was to be the will of this committee. I don't think it's needed or mandatory, because I think that's inherent, implicit in the whole function.
Thank you.
Thank you.
Whip Park.
Thank you, Mr. Chairman. I had a few questions as well along the lines of those asked by my colleagues. Senator Calser, certainly appreciate your intent of what you're trying to do. Now, I don't think, as you may have stated earlier, that this bill is simply codifying or making a clearer existing law. My understanding with respect to the subpoena power of legislators is that the Georgia Supreme Court has not issued a ruling affirming or denying the power, but it was a superior court that affirmed the Senate committee's subpoena power specific to the circumstances involving Madam District Attorney Willis.
They haven't, because it hasn't been appealed. She apparently agrees with the ruling.
So
The court has ordered her to produce documents and to provide a time to appear for a deposition, and they have agreed, by the way, to produce the documents. So there's not going to be a need for that to be appealed.
but just so that we are all clear, this legislation would be codifying explicitly a new power, which
No.
would be that subpoena power.
I do not agree. No, we already have that power. We have it in the code section, and we have it in the Constitution. And
Implicitly.
Implicitly, just like judicial review. Constitution doesn't say the Supreme Court can review our actions to see whether or not they're constitutional. But Marbury versus Madison said, hey, this Constitution doesn't work unless you have that power, or else we would never have to follow the law. Nobody could hold us accountable. The Supreme Court has a series of cases that have said the same thing. The legislature has the power to investigate so they can do their role as the legislative branch. And then we have code sections as well that allow that weren't even necessary to start with, but they give us comfort. And I just wanted to put it in the section under the General Assembly so it would be clear. And trust me, I am well aware of the what's good for the goose, what's good for the gander rule. There is nothing in this that I wouldn't gladly allow the minority party to exercise whenever they become the majority party again. That this is equal-handed for the institution of the legislature, and let the politics shake out where they might. The voters will decide what party they want in control.
So I would respectfully disagree with a few of the comments made. One, I don't think voters would want to see more politically motivated, partisan, secret investigations that this bill would likely permit. I think with respect to ensuring the confidence of all voters, not just voters of one political persuasion, one, we have elections that you know, for example, with District Attorney Fonnie Willis, she won her election with 80% of the vote. I think if anything, that where voters have an opportunity to hold elected officials accountable will instill trust, as opposed to, again, partisan committees with the power of subpoena that has no guardrails as to the purpose or what they are investigating. I would not want to see that as either a member of the minority or the majority. I think to the point that Representative Evans made, I mean, is it unreasonable to have in this legislation guardrails, at least two tiers of guardrails, one that would limit these sorts of investigations into, for example, areas related to the misuse of government resources, areas in which both Republicans and Democrats can agree upon that, you know, the legislature should have subpoena power, as opposed to, again, allowing partisan committees, whether you're in the majority or minority, liberal, conservative, to engage in politically motivated partisan investigations, which again, this bill would currently permit.
Okay, well, I got to push back a little bit. There is nothing secret about this at all. We have the most open legislative process in Georgia of any state. I would imagine I'm on camera right now, and if you're sitting at home on your computer, you can watch and see what I say. All of our committee rooms are broadcast, live streamed, and they have to be announced 24 hours in advance. That's why we have agenda, so the public will know what we're going to be discussing. Nothing secret. There has not been a single committee meeting of the Senate Investigative Committee that has not been live streamed, and also televised for that matter, if the press was interested. So I reject anything that this creates some kind of secret star chamber or somebody to do investigations that are in the dark of night. That's not true. Do you want to add something to this to create partisanship? Have at it. I mean, if that's the will of this committee, this is not intended to be partisan in any way. It's the body, the Senate or the House. If their rules and their resolution, their majorities pass what you want if you feel like you need to investigate. That's where it's coming from, the heart, not some sneaky side attack. You were talking about, the Fonnie Willis thing. Well, it was the judicial branch that ruled that her conduct was inappropriate and made her be removed from that case. Our committee didn't do that. Nobody here did that, but we heard about this appearance of impropriety, and that it's, by the way, been upheld by the Court of Appeals. No legislative input here whatsoever. But when they started talking about it, the question became, is it clear what behavior is inappropriate? That's improper, relationships or whatever, or use of special prosecutors, and that's what we do. What we want to do here is let's pass bills and say, this is what we expect of our prosecutors, the conduct, so that makes their lives easier in the future as well, so they don't have to wait for the Court of Appeals to determine on a case-by-case basis. That's where we're trying to get. So I hope I can quell any partisan fears here that this is a weapon that's going to be used by either the Republican Party or one day the Democratic Party to attack people. It's to investigate and to legislate.
So just a few comments to your response, and then one final question. So, is it not true that Georgia's sunshine laws do not apply to the state legislature?
That is true.
Okay. And, I think with respect to, the structures, the bicameral nature in which this bill would apply, I think I would be a little more comfortable had we, had independent redistricting reform to ensure that, again, voters have an opportunity to choose their elected officials, as opposed to, some of the gerrymandering that, again, provides a partisan slant that then allows a partisan committee under this legislation to proceed in a way that, again, is, they can proceed in a politically motivated manner if they so want. I trust and I understand your intent. That is not what I'm assailing. It's the potential effects and the harmful unintended consequences that may result from this legislation, whether Democrats or Republicans are in the majority, that I'm concerned about. Last thing, again, going back to guardrails, both as to scope of limitation, but can you speak to guardrails with respect to separation of powers? Is there judicial oversight over these investigations? Can you speak a little bit more to that?
Okay, as I mentioned earlier, if you get into the enforcement provisions of this, and that is really lines like 30 on page 2. What do you do if you issue a subpoena? Here's back to separation of powers. Legislative branch issues a subpoena to somebody in the executive branch or somebody in private practice that they want to know what's going on so they can solve a problem. This is where the judicial branch steps in, because to enforce that subpoena, you go to the superior court where you're trying to compel the production of documents or the testimony, and that judicial branch then gets to determine whether it's reasonable what you're seeking, whether it's justified by the law, by the scope of the resolution creating that committee. And only if the judge says your subpoena was enforceable, the recipient did not have just cause to do it, can they be compelled to comply. So that's the best I can tell you as far as the separation of powers. It's implicit in here.
Well, with respect to enforcement and holding folks in contempt, I certainly understand where the court would be coming in. At least my reading and additional concern is that this may be undermining the judiciary and checks and balances with respect to, whether certain subpoenas are treated confidentially or not. I'm looking at lines 44 to 52. If a court states that confidential treatment is not warranted, would a partisan committee be able to, proceed?
Yeah, if that separate branch of government, if the judicial system said, so what that would come up is if you ask for some sensitive information, and the recipient of the subpoena said, I don't want to give this up unless I can be told it will be kept confidential. And that's what this gives you the proper ability. If the subpoena issuer doesn't agree to hold it confidential, the judge can order you to do that. So I mean, that's a protection for people from having to disclose confidential information in order to assist us to do our job. I mean, you're talking about the judicial branch. Well, they ought to welcome our investigation. We just voted them a pay raise. And we did that after committee hearings, being told by public comments, our judges are underpaid and we need to pay them more to get good qualified people to do that. Well, what if they refused to tell us what their fringe benefits were and we couldn't, or their retirement package, and some committee said, well, by golly, we're going to order a subpoena so we can learn this information. We would have the right to do that. We'd actually have the duty to do that, to properly legislate. So it's all this three-legged stool with the judicial, executive, and legislative branch. This just makes it clear what our powers are, and it sets limitations on them.
Again,
Okay, we've had some really good explanations and some really good questions. You got one more question to wrap it up, okay?
thank you, sir. So when all is said and done, I appreciate your intent and where you're coming from with the bill. Per your analysis, in which the subpoena power of a legislative body has been used maybe once in 30 years, maybe not, maybe it won't be used for another decade, along with all of the potential problems that this may cause, including undermining the trust that voters have for us as legislators to be fair and to act in their best interest. I think additional work may likely be needed on this, again, just to ensure guardrails that instills public confidence as opposed to potentially creating another tool for politically motivated investigations. But thank you so much.
Okay, like I said, we've had good conversations and good questions. Recognize Chairman Hatchett.
At the appropriate time, I'd like to move do pass SB 255, substitute LC 47368 1S.
This would be the appropriate time. We
So
have a
moved.
motion. Is there a second? Second. Have a second. Any conversation? All those in favor say aye. Aye. All those opposed say no. The ayes have it. Okay, it passes.
Mr.
Thank you.
Chairman, I had my button pushed to make an amendment. If we're going to be a committee, it seems like the members should at least have a chance to have discussion and amendment.
We had already gone through all of these, and you'd had questions and several others too, but I didn't know that you wanted to make an amendment. I'm sorry.
Well, that's why I pushed my button. I don't know how else to be recognized in here.
Okay.
I'll yell out next time, if that would be the
fine.
preference.
That'd be fine. Okay,
Thank you, Mr. Chairman.
thank you. Okay, that takes care of those two items. Now we're going to adjourn the House Rules Standing Committee and convene the Committee on Rules. Got a couple of cleanup items we need to do here. Let Leo pass out some documents to you there. Okay, I've had a request to recommit Senate Bill 51 back to the Committee on Governmental Affairs. Do I hear a motion? Have a move and a second. All those in favor say aye. Aye. Any opposed? Okay, it's back in committee. Senate Bill 9 was presented to the committee several days ago. and it's on our consideration calendar. I have a substitute to Senate Bill 9, and that's what you should have there. It's the exact bill that we had with one exception. The only changes are on page 6, on lines 124 through 129, adding the definition of person. Give you a chance to look at that. If you've had a chance to look at that, I'd like to entertain a motion that we do pass by substitute Senate Bill 9 with that one addition there.
Mr. Chairman,
Yeah. Yes, ma'am.
I'd like to make a motion that we adopt LC 560401S as the rule substitute to SB 9.
Okay, we have a motion and we have a second. Is there any opposition? Okay, it's adopted then. Okay, now, let's do this. Let's set a calendar for, rules calendar for tomorrow. That'll be Thursday, legislative day 36. Okay, Senate Bill 9 as rule substitute, the LC 560401S. Have a move and a second. Is there any opposition? It's on. Senate Bill 63. Have a move and second. Any opposition? It's on. Senate Bill 72. Moved and seconded. Any opposition? It's on. Senate Bill 85. Moved and seconded. Any opposition? It's on. Senate Bill 233. Moved and seconded. Any opposition? It's on. Okay, that sets our calendar for Thursday, and we are adjourned. Thank you.